Good afternoon, everyone, and welcome to Holland & Hart's Healthcare Webinar Series. My name is Teresa Locke, and I'm an attorney in the Denver, Colorado office of Holland & Hart. Today we're going to talk about HIPAA for business associates. And I chose this picture to begin our presentation because, much like a hippopotamus, HIPAA can be a dangerous creature, but it doesn't have to be. And just like this zebra and hippo, we can coexist with HIPAA so long as we respect it and comply with its requirements. So the purpose of this presentation is to help you maintain a peaceful coexistence, so to speak, with HIPAA. This is our obligatory legal warning that this is an educational talk and it does not constitute legal advice, but just as a plug, if we don't already represent you, we'd love to represent you. So let's move on to our topic today. So the overview of what we're going to talk about today are these items. Why should you care about HIPAA? Who are business associates? What must business associates do? And under that category, we're going to talk about 4 different things: business associate agreements, security rule requirements, privacy rule requirements, breach notification rule requirements. And we're also going to talk about liability for business associates and their subcontractors, and then we'll provide you with some additional resources. We have a lot to cover today in a short period of time, so we're going to move fairly quickly, and I hope that we'll have a little bit of time left at the end for questions, but if we don't, you can certainly submit your questions to us anyway, and we'll get them back to you in writing by email. So let's dive right in. We also want to provide you with some written materials. You'll have these PowerPoint slides. They're available on Holland & Hart's healthcare blog that you can pull them up. Another piece of written material that we will be referring to later that might be helpful for you to get is the sample business associate agreement that's on the HHS website. And then my colleague Kim Stanger, who many of you know, has various publications on our H&H website that apply to this and would be very helpful and beneficial for you to take a look at. So HIPAA, as you probably already know, stands for Health Insurance Portability and Accountability Act. It's HIPAA, not HIPPA, as many people seem to get it wrong. Just to give you very briefly a little bit of history about the rules that we're going to talk about today, HIPAA came into existence back in the mid-90s, but the rules that we're going to talk about today are the HIPAA Privacy Rule from 2003 that requires healthcare providers and health plans that are identified as covered entities to protect the privacy of protected health information. And throughout this presentation, I'll try to refer to that as PHI because it's so much easier to say. The privacy rule also talked about executing business associate agreements with business associates. We're going to spend a lot of time talking about that. The HIPAA security rule came in a few years later in 2005, and it applies to electronic PHI. Then there's the HITECH Act in 2009, which gave more requirements for business associates to comply with HIPAA and strengthened the HIPAA requirements and the penalties for violations. And then finally, the omnibus rules that became enforceable in September of 2013, which finalized and implemented the HITECH Act. There have been, recently there was an amendment to HIPAA that has to do with the Mental Health and Brady Act reporting requirements, and we did a client update on that. You can find that on our website as well. So why should you care about HIPAA? Well, in contrast to that first slide that I presented that showed that the zebra and the hippo can coexist, HIPAA can be very dangerous and can eat you alive if you're not careful and not respectful of all of the regulations and requirements. And it applies to business associates as well as covered entities. And even as this picture shows, business associates and covered entities really need to work together when it comes to HIPAA. The first reason, really, that you should be concerned is that there are civil penalties associated with violations of HIPAA. Those civil penalties are found in the federal regulations. We give you the site at the top of this this slide, and it's a four-tier structure, and the penalties get worse as the culpability increases. And so you can see from the first category, if you didn't know and didn't have a reason to know of the violation, then the penalties are lesser, and there's no penalty in that category if you correct the problem within 30 days. If you don't correct it within 30 days, but you still didn't know or shouldn't have known of the violation, there's still an opportunity to have the penalty waived or reduced per the statute. Second category is a violation due to reasonable cause, and reasonable cause is defined as an act or omission in which a covered entity or business associate knew or by exercising reasonable diligence would have known that the act or omission violated a provision, but didn't act with willful neglect. So a little more culpability, but there's still the opportunity for no penalty if it's corrected within 30 days and an opportunity to have the penalty waived or reduced under certain factors. When you get to the last two categories that are in red, willful neglect, those are the big ones. And willful neglect is defined by the regulations as conscious, intentional failure, or reckless indifference to the obligation to comply with the provision violated. So that's a much higher or worse violation, and the penalties in this category, these two categories, are mandatory, but if you correct it within 30 days of discovering it, then it's a lesser penalty than if you don't correct it within 30 days. So civil penalties are significant, and it's important to note that when you're looking at the civil penalties, counting them, the statute provides, or the regulation provides, that if the violation results in the disclosure of information for multiple individuals, such as the loss of a laptop, then each individual is a separate violation. So the violations can add up very quickly. And if the violation results from failure to implement a safeguard or policy that's required by HIPAA, each day that you haven't implemented that policy is a separate violation. So again, they can add up very, very quickly. The HHS website, Health and Human Services website, has a link, and you can see the link on this slide, where you can click on it and read examples of fines and penalties that people who have violated, or entities that have violated HIPAA, have been hit with, and those are significant numbers. And this slide is even a little bit outdated. There are even more on there. So in case you're wondering whether HIPAA should be followed, it should, and here's your motivation. But there's also motivation in criminal penalties. So there's a federal statute that's cited at the top that can provide criminal prosecution if employees or other individuals obtain or disclose the PHI from a covered entity without authorization. Again, there are tiers to this, so it sort of depends on the level of culpability, but those are significant. And it's also important to note that individuals can be, it's not just an entity issue, it's an individual issue. So in accordance with principles of corporate criminal liability, there can still be issues where a director or employee or officer can be charged with a criminal violation. The first one, knowingly obtaining information, is important to discuss because this case that's on this slide from the Ninth Circuit taught us that knowing only means that you knew you obtained the information, not that you knew it was a violation or that you knew what you were doing was inappropriate. So that's a pretty that's a pretty significant issue to keep an eye on. If you knew that you took the information, that could subject you to criminal penalties. In addition, the statutes and regulations now allow for state attorney generals to bring lawsuits and sue for $25,000 per violation. So this is not a penalty. This is a civil lawsuit, and that's becoming a little bit more common. This is from 2012, where a business associate was sued by the Minnesota Attorney General. It involved a laptop that had been left in a rental car that it contained unencrypted health data for about 23,500 patients. And this was a collection agency that had this information, so it was a business associate. And the Minnesota Attorney General sued and got a judgment for $2.5 million. And the entities, or the business associates' problems didn't end there. The FTC also brought a claim, and their stockholders brought a claim. So one laptop being left behind in a rental car amounted to millions of dollars of costs for this entity. So if those issues were not enough to make you want to comply, then here are some additional reasons that you would want to comply with HIPAA. You're going to have unhappy clients. Their clients may need to terminate the service agreements that you have. It's likely that individuals can probably bring lawsuits against you. Even though there's not a private cause of action under HIPAA, they could claim that HIPAA is the standard of care and you've breached a standard of care. And they could also sue for a breach of the business associate agreement because they're a third-party beneficiary under that. In addition, another reason why you want to comply is because you have to self-report breaches of unsecured PHI. So a business, we'll talk about this all in more depth. This is kind of an overview right now, but business associates have to notify the covered entity, and then the covered entity has to notify of individuals, HHS, and if it involves more than 500 people, the media has to be notified. So there are lots and lots of reasons to take HIPAA and its rules seriously. The good news about all of this, though, is that it really, the rules are out there. There's lots of information on them, and we're going to talk about lots of sources that you can learn and get guidance from and can follow all of these rules. And if you follow the rules, you can usually avoid civil penalties if you implement policies and safeguards, and we're providing you with a lot of material to help you do that. Train members of your workforce and document your training so that the OCR can see what you've done, and you can use these slides and other materials that we're providing you to be able to provide that training, and respond immediately to a possible violation, mitigate any damages, avoid so that you can avoid breach reporting obligations. And if you're not acting with willful neglect and you correct the violation within 30 days, then you can get away without penalties at all. So there are lots of ways to make sure that you're not getting hit with penalties. So who does it cover and what does it cover? First, what does it cover? It covers protected health information, and that the regulation provides or defines protected health information as individually identifiable health info that could be used to identify an individual, so names, email addresses, account information, those types of things. They also have, not only does it have to identify an individual, but it has to concern their health, physical or mental health, health care, or payment. It needs to be created or received by a covered entity, which we'll talk about in just a minute, and it's any kind of information maintained in any form. So it can be oral, paper, electronic, et cetera. What's not covered is de-identified information. So if you cannot tell who the individual is, there's no identifying information, then it's not protected health information. Covered entities, so these are the people that HIPAA applies to, and the regulation defines those covered entities as healthcare providers who engage in certain electronic transactions, health plans, including employee group health plans if there are 50 more participants or administered by third-party administration. Those are sometimes the forgotten HIPAA target, but they are really important. And then healthcare clearinghouses. Also covered by, did I go too fast? No, there. Also covered by the HIPAA obligations are business associates, and obviously that's the subject of this presentation. Business associates are entities that create, receive, maintain, or transmit PHI on behalf of the covered entity. So these entities perform a function or activity that's regulated by HIPAA. They perform certain identified services such as billing or claims management, legal, accounting, consulting services, even interpreters or quality assurance individuals are covered as business associates. Health information organizations and e-prescribing gateways. Data transmission companies are business associates, but only if they routinely access the PHI. On the other hand, data storage companies, so cloud computing, off-site storage facilities, are business associates even if they don't access the PHI. And then patient safety organizations. Then in addition to sort of those business associates, covered entities can act as a business associate, and business associates themselves can hire subcontractors to perform some of their work. They're considered business associates under these rules. So this is just a graphic to show you kind of where if a covered entity provides protected health information to business associates and then business associates provide it to subcontractors, both of those lower categories are counted as business associates and are covered by what we're talking about today when we talk about business associates. So who's not a business associate? Well, members of a covered entity's workforce are not. Entities who do not handle PHI as part of their job duties are not, so a janitor, a mailman, those kinds of things. Entities that receive PHI to perform functions on their own behalf, not on behalf of the covered entity, such as banks, those are not business associates. Other healthcare providers while providing treatment, so people that are providing treatment to the patient are not business associates. Data transmission companies that do not routinely access PHI, if they're just a mere conduit of the information. Maybe data storage companies that receive encrypted PHI and don't have the key to interpret it. And we say maybe because there's a little bit of gray area in that. And then members of organized healthcare arrangements are not business associates. And I refer at the bottom to see the article Avoiding BAAs. This is a publication that's on our website that was put out by Kim Stanger that's really helpful on determining a business associate. He also created this business associate decision tree, which can help you walk through the questions, and because of time I'm not going to walk through those, but it's very helpful to determine whether an entity is a business associate or is not. And it's important to determine whether they really do fit the definition, because there are requirements that we're going to talk about right now for business associates that wouldn't apply if they're not a business associate. So what are the obligations of a business associate? First, there has to be a business associate agreement with the covered entity. So the covered entity and the business associate have to execute and comply with the terms of a business associate agreement. They also have to comply with security rule under HIPAA, and we're going to talk a lot about that, but the basic kind of things are appointing a security officer, performing and documenting a risk assessment, implementing required safeguards, executing agreements with the subcontractors, maintaining policies and procedures, and training their personnel. And we note that this may be difficult for some business associates to comply because of the size and et cetera, but they must comply with the security rule. Business associates must comply with the minimum necessary standard, which is giving out PHI in the most limited form necessary to satisfy the need. And they have to report breaches of unsecured PHI to the covered entity. Business associates under HIPAA are directly liable for a list of things here, and those items are use and disclosure in violation of the business associates agreement or the privacy rule, failing to comply with the security rule, failing to notify covered entities of a reportable breach, failing to disclose PHI to HHS in response to investigation, failing to disclose PHI in response to an individual's request for their electronic PHI, failing to execute agreements with their subcontractors, and failing to address a breach of those agreements by the subcontractor. So all of those make business associates directly liable for the violation. So let's talk about the first one, the business associate agreement. As I said, covered entities must have an agreement with the business associate before disclosing any PHI to the associate or authorizing that business associate to create or receive PHI for the covered entity. The agreement itself must limit the business associate's use of the PHI, and I'm going to talk to you about other things and ways to get all of these provisions covered and examples that you can use. But the business associate also must have a business associate agreement with its subcontractor if it's going to subcontract any of the work out, and that agreement must mirror or match the agreement between the covered entity and the business associate. The business associate agreement, the business associates must comply with the terms of the agreement and must comply with HIPAA, even if there isn't a business association agreement, and there should be. That doesn't relieve the business associate from complying with HIPAA. So this is another graphic just so that you can see that there needs to be an agreement between the covered entity and the business associate, and then an agreement between the business associate and the subcontractor that mirrors the same agreement. So if they need to match each other. So here are some required terms. HIPAA sets out specific required terms that must be in the business associate's agreement. So first, it has to establish permitted uses of the PHI. So business associates may only use or disclose PHI as allowed by the agreement or as required by law. They may allow business associates to use it for its internal management or administration, but they cannot use or disclose the PHI in a manner that would violate the privacy rule if it was done by the covered entity. One thing that we want to make sure that you're aware of or be aware of is that sometimes covered entities have even more stringent things that they commit to in their notice of privacy practices with their patients. And so it's important that the business associate know what those are and see those so that they don't violate them. More required terms. Sorry, my slide's not advancing there the way I want it to. Okay, there we go. They have to have something that says that they're going to implement safeguards to protect the PHI. Under the privacy rule that we'll talk about in a minute, there are not specified safeguards, but they need to have some sort of safeguards in place. The BAA is going to require that they comply with the HIPAA security rule and the various requirements under that, and we're going to go into more detail on that in just a second. It's also a required term that the agreement says that the business associate has to report back to the covered entity if there is a breach of unsecured PHI or if there's use or disclosure of PHI that's not allowed by the agreement. That needs to be reported back to the covered entity. HIPAA violations, even if it's not a reportable breach, which I'll define for you in a little bit, it still needs to be reported to the covered entity. The BAA is going to require that if there's a violation of the agreement, even if it doesn't violate HIPAA, it needs to be reported back. So there's a lot of reporting obligations put in these agreements. And then they also have to report if there's a security incident, and that's where somebody attempts, either successfully or unsuccessfully, to have unauthorized access, use, disclosure, modification, destruction of the system. So those all have to be reported to the covered entity, and they need to be included in the terms of the business associate agreement. Here are a few more terms that must be included in the business associate agreement. They have to be obligated to cooperate in providing individuals with access to their own PHI, to amend records in the designated record set, to provide an accounting of disclosures of PHI in a designated record set. So that means they're going to have to log improper disclosures and certain functions, or excuse me, certain disclosures for public safety or governmental functions. And that's going to require a logging of the date of the disclosure, the name of the entity, the description, and the purpose. So there's a lot of logging and recording requirements. We've talked about this already, but if if the covered entity delegates its functions to a business associate, then the business associate agreement says that the business associate has to comply with HIPAA as to those functions. They have to make their internal records available for inspection. They have to execute the agreements with subcontractors. The BAA needs to include terms about authorizing termination if a business associate violates the terms and what's going to happen upon that termination, returning and destroying all the PHI if feasible. If it's not feasible, then they have to comply with whatever parameters are set in for what they need to do to protect it if they keep it. So all of these things are things that must be included in the business associates agreement. Here's a screenshot from the HHS website that has a sample business associate agreement that we would encourage you to take a look at so that you can make sure that you're covering all of the terms that are necessary. We want you to be aware, however, that there are some terms that covered entities may want to add that are not required by HIPAA, but they would give more protection to the covered entity. And so these are things, I won't take the time to go through all of them. You'll have this slide and you can read them all, but they're things that are not required by HIPAA, but they would help the covered entity by passing some of the burden to the business associate that otherwise would be the covered entity's burden. So while if you're a business associate, you may not want these types of terms in your agreement with your covered entity, you may want them in your subcontract, and since the two need to mirror each other, you sort of get them both direct. If you're going to ask the subcontractor to abide by them, then they may need to be in your other contract with the covered entity. On the flip side of that is here are some pro-business associate terms that you would want to try to negotiate into the agreement. And again, they're not things that are covered by HIPAA, but they would provide the business associate with more protection and more benefit. And so they're worth at least looking at and determining whether you might be able to negotiate some of those terms into your agreements. As I said, covered entities may ask you to sign a business associates agreement even if you're not a business associate. We talked about making sure that you are a business associate before you sign one of those agreements. If you're asked to do that and you don't qualify as a business associate, then you can try to explain to the covered entity sort of what the limits are and why you shouldn't be covered by it. But know that if you sign the agreement, you're accepting some liability. Again, the covered entity may insist on terms that are not required or that exceed the scope of HIPAA, and as a business associate, you can try to explain to them what the limits are and explain that the covered covered entity generally is not liable for acts of the business associate. We'll talk about sometimes at the very end of this presentation when they are, but generally they are not. But frankly, as a practical matter, if you want to do business with the covered entity, you may have to agree to terms that you wouldn't otherwise want to agree to. So summarizing the agreement piece of this presentation, do not assume the liabilities under a business associate agreement unless you have to, unless you are a business associate, and unless they are required by HIPAA. Review the terms of the agreement carefully. Beware of terms that aren't required by HIPAA. Beware of terms that increase your liability. Try to negotiate more favorable terms if you can. Once you get the business agreement in place, then make sure that you comply and ensure that your workforce understands the requirements and what kinds of disclosures that you have to make. Now, and I see some people have questions. I'm going to save those to the end, and if we have time, we'll answer them verbally. If not, we'll get you the written answers to those. But I'm going to move forward to the next piece of compliance under business associates, and that's the HIPAA security rule. The citation is found at the top of this slide. The security rule is designed to protect electronic PHI, and it's only related to electronic PHI. There's sort of three purposes of the security rule: to increase confidentiality, to increase integrity, and to increase availability of the information. As an overview, the general requirements are that you have to conduct risk analysis of system vulnerabilities, implement specific administrative, technical, and physical safeguards, execute business associate agreements — you're going to get tired of hearing that by the end of this presentation — maintain written policies, and train your personnel. So that's kind of the overview. Now let's, so the good news is that most of this stuff isn't rocket science. You're probably already doing a lot of this because it involves common sense precautions to protect your own business. So you really are probably already protecting your own systems, protecting your information, protecting individuals' information. But if you aren't doing it, you should be doing it for your own protection. So that's where we're going to go next in talking about what's required, because without the security process and procedures in place, there's all these hacks that have been occurring, and here's some of the headlines, and certainly we don't want to see any of our clients' names in the headlines, and there's lots of very creative people out there who have ways of hacking, so we're trying to avoid that. So the first thing under the security rule was conducting a risk analysis, and that's what the regulation provides, that we have to conduct an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, and availability of electronic protected health information. There's not a particular analysis that's required, because the analysis is going to vary depending on the size of the entity and the resources. And you can conduct this analysis internally. You don't have to hire some outside firm to do this, but the analysis should be ongoing. There are guidances available for risk analysis. There's a couple good ones here. This first one is put out by HHS, and you can see the link in the slide of where you would go, and they give guidance on performing the risk analysis. The next one is on healthit.gov, and it contains a security risk assessment tool. I think it's 156 questions that you can use to that ask questions about your organization, and you can determine what your risk is and doing the assessment. And then there's a publication that was put out by the National Institute of Standard and Technology. It's pretty lengthy. You can see by this little screenshot that it's 95 pages, but it's probably worthwhile if you're in the security piece of your organization to take a look at this. So we talked about how there are sort of excuse me, three prongs of safeguards that are necessary under the security rule. There's the administrative safeguards, physical safeguards, and technical safeguards. And for each of those, there's a regulation found in 45 CFR 164, 308 to 312. And there are standards that are set forth, and then there are implementation specifications. And there are two types of specifications. They'll be referred to as in parentheses as R or A, required or addressable. And required are, exactly what you would expect them to be. You must implement the specification. Addressable does not mean that you don't have to do it. It doesn't mean that it's not required. What it means is that you have to assess the reasonableness of the specification, and if it's reasonable, implement it. If it's not reasonable, you have to document why it's not reasonable. Is it because of the size of your organization or the cost or risk factors? And implement an alternative if reasonable. You must review and modify this as sort of an ongoing process as needed. The safeguards are not technologically specific because there are going to be technological advances. So there's a lot of discretionary areas in there as to how you implement these safeguards. You may use measures that reasonably allow you to comply with the standards, considering your size, the complexity, technical infrastructure, cost, the probability and of the risks, et cetera. So so that was the sort of overview about safeguards. Now we're going to talk about each of the three. So recall that the first one was administrative safeguards. So there's a list of things that you have to do under the security rule for administrative safeguards. You need a security officer. You need to implement policies, procedures, and safeguards to minimize the risk. Excuse me. And as an aside, the United States Department of Health and Human Services has said that the majority of security rule violations that they investigate result from a covered entity not having adequate policies and procedures in place to safeguard the electronic PHI contained on a system. So policies and procedures are really important. You also need to sanction workforce members if they violate policies. There needs to be some teeth to this. You need a process for authorizing and terminating access to protected to electronic PSI. You need to train your workforce members. You need to have a process for responding to security incidents that happen. You need to review or audit your information system activity, establish backup plans, disaster recovery plans, et cetera, and you need to periodically evaluate these security measures to make sure that they are still appropriate for the environment. The second, so that was the administrative piece of the security rule. Now we're going to talk about the physical safeguards. You need to limit access to the physical facility and for devices containing the electronic PHI. You need to document repairs and modifications to the facility. You need to secure workstations of your employees who have access. You need to implement policies concerning the proper use of workstations, what kind of privacy they have. You need to implement policies concerning the flow of the electronic PHI into and out of the facility. You need to implement policies for disposal of electronic PHI, and you need to create a backup copy of the PHI. So these are physical safeguards. Then there are technical safeguards that are listed in the regulation. You need to assign unique names or numbers to track users, implement automatic log-off process so somebody doesn't stay logged into the computer. You need to use encryption and decryption where appropriate. You need to implement systems to audit the use of the PHI. You need to implement safeguards to protect the PHI from alteration or destruction. Implement methods to ensure that the electronic PHI has not been altered or destroyed. Implement verification processes, and last of all, protect data during transmission. So these are safeguards that are under the security rule. As with all the other privacy rules, et cetera, there is good guidance on the HHS website on security rules. You can see from this screenshot lots of links to various things that explain all of these, the administrative safeguards, physical safeguards, technical safeguards, explain them in more depth, but the one I wanted to point to is the one right in the middle of the screenshot that says Security 101 for covered entities. This is a screenshot of that. If you click on that link, what you get, and it's a great topic from HHS on the security piece of this. And then another website that you can look at to learn more about security and privacy and what you can do to implement these things is the healthit.gov website. So in addition to implementing all of those things, you need to document it, and documentation is extremely important. So you need to document that you've implemented these policies and procedures. You need to maintain the documentation for 6 years from the later either of the creation or the last effective date. You need to make the documents available to persons responsible for implementing the procedures, and you need to review and update the documentation periodically. So just to summarize the security rule, you need to document your good faith risk analysis. You need to work with IT to implement those safeguards that we went through. If they're required, they must be implemented if they are addressable. Then you need to document what your evaluation is and figure out what you can implement, and if you can't implement it because of size, et cetera, then what can you implement to accomplish the same thing. You need to develop policies concerning the safeguards. You need to execute business associate agreements, yet again. You need to train your personnel, respond promptly to any violation, and again, document your actions. Very, very important. So we've talked about now business associate agreements. We've talked about the security rule. Now we're going to move to the privacy rule and how the privacy rule affects business associates. So business associates may only access, use, or disclose PHI as permitted by either the agreement that they've signed with the covered entity or by applicable law. So we want to make sure that the agreement has what your authorization is, what uses and disclosures you're authorized to make. You can't use the PHI internally unless it's allowed by your business associates agreement, so that you would want that to be contained in there. Again, business associates, if you're going to have a subcontractor do part of your work, then you cannot disclose that private health and protected health information to the subcontractor unless you also have a business associate agreement with them that tracks the limits that match, sort of mirror what's in the covered entity business associate agreement. While the privacy rules themselves do not directly apply to business associates, most of them, because they can't use or disclose the PHI in a manner contrary to limits placed on covered entities, then likely business associates are going to need to implement many of the same policies as a covered entity will. So the business associate may not access, use, or disclose PHI in a manner that would violate the privacy rule if it was done by the covered entity. So you should confirm whether, again, the entity has any sort of additional restrictions through notice of privacy practices or other agreements to make sure that you are following those. So the reasons that a covered entity or a business associate can access, use, or disclose are for purposes of the covered entity's treatment, payment, or healthcare operations as required by other laws, for certain safety or government purposes that are listed in a particular regulation that we have cited, or if there's a valid written authorization from the individual. When those disclosures are made and they're authorized, the business associate still has to use reasonable efforts to limit the disclosure of the PHI to the minimum necessary to accomplish the intended purpose. So that's the minimally necessary standard, only what's necessary to accomplish what was requested. So the net effect of the privacy rule as it refers to business associates is don't access, use, or disclose the PHI unless it's within the scope of your service agreement or your business associate agreement, or you're directed to disclose it by the covered entity, and do not request, access, or use more than is minimally necessary for the requested purpose. We put those in red because those are sort of the takeaway overall for the privacy rule. So the privacy rule has some reasonable safeguards as well, and it's very similar to the security rule in the sense that there are administrative, physical, and technical safeguards that you can put in place to limit improper intentional or inadvertent disclosures. There is no liability for incidental disclosures if you have implemented the reasonable safeguards. So if you've got safeguards in place and it's sort of incidental disclosure, then you're still protected because you've put reasonable safeguards in place. The problem, of course, is what's reasonable. That's a very subjective term. Fortunately, the protections are scalable so that the OCR will look at the size of your entity, et cetera, to determine what is reasonable. Overall, it should not interfere with healthcare, and we've listed a guidance there that you would want to take a look at to kind of see what the OCR is saying about what is a reasonable safeguard. In addition, we, under the privacy rule, you have to track disclosures. So the business associate agreement, we talked about this being a provision, a mandatory provision in the business associate agreement to make it mandatory for them to assist the covered entities in accounting for disclosures. So the business associate has to track disclosures that are in violation of HIPAA and disclosures that are either required by law to avoid serious harm or to certain government agencies, and you can take a look at that regulation to get more detail on that. The business associate should log the date of the disclosure, the name and address of the entity to whom the disclosure was made, describe the PHI that was disclosed, and describe the purpose of the disclosure. Again, this is a repeat of what we talked about earlier, but it's extremely important. And of course, another part of tracking the disclosures is reporting those to the covered entity. So now we've talked about business associate agreements, we've talked about the security rule, we've talked about the privacy rule. Now let's talk about what requirements there are for breach notification on business associates, and that's found at 45 CFR 164.400 and thereafter. So if there is a breach of unsecured PHI, so we're going to talk in a minute about what both of those terms mean, a breach of unsecured PHI, then the business associate must notify the covered entity. And then the covered entity must notify each individual whose unsecured PHI has been or reasonably believed to have been accessed, acquired, used, or disclosed. The covered entity must also notify Health and Human Services, and if more than 500 persons are affected, the covered entity must notify the media. Now, naturally, these reports, once the breach is reported, will likely result in patient complaints, OCR investigations, penalties, either civil penalties, potential criminal penalties. So it's a big deal, and we want to try to avoid them. So what is unsecured PHI? Well, I guess to talk about that, we talk about what's secured. Currently, there's only two methods to secure PHI. One is encrypting electronic data. So you're transforming the data into a form so that it doesn't have much meaning unless you have a key to decrypt it. And the National Institute of Standards and Technology provide ways of doing that. So that's one method of making data secure. The other is just destruction. So if it's a hard copy or film, et cetera, it has to be shredded or destroyed such that info cannot be read or reconstructed. And if it's electronic media, then it has to be cleared, purged, or destroyed consistent with the NIST standards that we talked about above. So that's what is secured data, therefore everything else is sort of unsecured. And these guidance are updated annually, and you can look on the HHS website about that. So that's what unsecured PHI is. Then what is a breach? So acquisition, access, use, or disclosure of PHI in violation of the privacy rules, so outside of what was allowed by the privacy rules, is presumed to be a breach. Unless you can demonstrate that there's a low probability that the info has been compromised based on a risk assessment of the following factors. So whatever the nature and extent of the PHI, the unauthorized person who used or received the PHI, whether the PHI was actually acquired or viewed, and the extent to which the risk to the PHI has been mitigated. So it's presumed a breach unless you can demonstrate that there's a low probability that it's been compromised using these factors, or unless an exception applies. So the exceptions are a breach does not include the following: unintentional acquisition, access, or use by workforce member if made in good faith within the scope of their authority, and the PHI is not further disclosed in violation of HIPAA privacy rule. that's one that's not a breach. Inadvertent disclosure by an authorized person to another authorized person at the same covered entity, business associate, or organized healthcare arrangement, and again, the PHI is not further disclosed in violation of the privacy rule. That's not a breach. And then it's not a breach if it's a disclosure of PHI where the covered entity or business associate has a good faith belief that the unauthorized person receiving the info would not be reasonably able to retain the information. So those are all exceptions to the breach. So here's like a little chart and a step-by-step process to determine if a breach occurred, because obviously if it's not a breach, then there's a lot less exposure, but if there is a breach and it has to be reported, then we have to take other steps. So here are the questions. Was there access, use, or disclosure? If so, did it violate the privacy rule? If so, there's a presumption that it's a breach unless there is a low probability that the info has been compromised, and we talked about the factors to look at, and then or if one of the exceptions apply. If you have to go through this analysis because there's a feared breach, you should really be documenting that so that you have proof of what you've done and what you tried to mitigate and why you did it. The business associate has to give notice to the covered entity if there is a breach of unsecured PHI. That has to happen without unreasonable delay, but no more than 60 days from the date of discovery. Or if the business associate agreement says something different than that time. Discovery is defined as the time that anyone, except the person who actually did the violation of it, knew or should have known of the breach. So from 60 days from that point in time, the business associate has to notify the covered entity. The notice should include, if possible, the identification of the individuals affected, the description of what happened, including the date of breach and how it was discovered and when it was discovered, a description of the type of protected health information affected, and what's being done to mitigate it. So those are the breaches of unsecured PHI that we've talked about. In addition to those types of reportable breaches, business associates also must report back to the covered entity uses or disclosures in violation of HIPAA, even if it doesn't rise to the level of a breach, use or disclosure in violation of the business associate agreement, security incidents where people have attempted or made successful unauthorized access, use, disclosure, modification, destruction of information, or interference with the system operations. And the business associate agreement may impose additional requirements on a business associate to report breaches or other violations. So all of those are important for the business associate to comply with to make sure that the covered entity is aware of what's going on. So obviously, reporting a breach can become costly. If you have a breach of unsecured PHI that involves more than 500 persons, so if it's a computer, if it's a laptop, if it's a backup disk or something like that, and it involves more than 500 persons, then the costs involve the time and cost to investigate it, the time and cost to prepare and send letters to those patients, personal representatives, or next of kin if it's a deceased person, the time and cost to respond to inquiries from patients or from individuals. Even, again, if you think about it, for 500 individuals, even if only 20% respond, that's 100 patients you're having to respond to and talk to, and there's a cost of a toll-free number for 90 days so that they can call in with inquiries. There's the cost of media notices and website updates. And, of course, the notice can lead to additional actions by angry clients or individuals, HHS, it's not listed on here, but attorney generals. There's media inquiries and bad publicity, just obviously something to be avoided at all costs if possible. So if you think you have a breach, what should you do? Well, first, act immediately to try to mitigate or correct the breach. Retrieve the information, try to confirm that it has not been disseminated any further and it won't be further disclosed. Notify a supervisor immediately, notify the covered entity if it's a breach and it needs to be notification. Correct the process so that it doesn't continue to happen. And do all of these things keeping in mind that prompt action can allow you to, satisfy your duty to mitigate damages, can avoid potentially the need to report a breach if you can catch it and keep it within the parameters that we discussed earlier. And the prompt action will help you defend against HIPAA penalties, because if it was in those first couple of categories, if you can correct it within 30 days, then there are no monetary penalties. So the last area, we've talked about business associate agreements, we've talked about security rule, privacy rule, and notification requirements. Now I want to talk just before we close the program about liability for acts of business associates or subcontractors. So as you recall, when we had the chart earlier, a covered entity can have a business associate. Then a business associate can have a subcontractor. So you really kind of have two levels of subcontracting, so to speak, one between the covered entity and the business associate, the other between the business associate and an official subcontractor. So the only way that the covered entity is liable for the acts of a business associate, or that a business associate is liable for the acts of a subcontractor, is if the covered entity or the business associate, the two people that are sort of at the top of the chain on those two things, either only if they knew of a pattern of activity or practice of the business associate or the subcontractor that constituted a material breach or violation of that obligation under the BAA. So they had to know of the pattern, they had to then fail to take reasonable steps to cure the breach or end the violation as applicable, or fail to terminate the contract or arrangement if feasible. So it's pretty easy to stay outside of this, because if you know about it, as long as you can take actions to cure the breach and end the violation and perhaps terminate the contract, then you don't have the liability for the person, for the business associate below the covered entity or the sub under the business associate. The other way that the two top levels, the business associate, or excuse me, the covered entity or the business associate can be liable is under the common law of agency. So under the common law of agency, the covered entity or the business associate could be liable for the acts or omissions of the person below them, or the entity, I should say, below them, if that lower entity was acting within the scope of an agency. So the test for that is, does the top level person have the right or authority to control the business associate's conduct? And the factors that would be looked at is, what does the contract say? Are they an independent contractor, or do you have the right as the top party, so to speak, to give interim directions or control the details? If not, then they're an independent contractor. Plus, you can look at the factors related to the relative size and the power of the entities. But obviously, if you're the covered entity, you want to make sure that you're not liable for the acts of your business associates. And if you're a business associate who is working with a subcontractor, you want to make sure you're not liable for their acts. So you want them to be independent contractors. So we're almost out of time, but I want to provide you with a few additional resources, talk about a few additional resources that are available for you. We've referenced a lot of them in screenshots through this PowerPoint presentation, and you'll have those, but HHS.gov has, as part of their website, a section on HIPAA that has lots and lots of links that you can reference and find a lot of the information, more details on a lot of the information that we've covered generically today. There's also healthit.gov, and it's a great website, and you can see the link to that of providers and professionals that you can learn more as well. And then, of course, our own website, which is found at hollandhart.com, and then the practice group Healthcare. And on our website, we have a blog that you can link to. We have webinar recordings for past webinars that we've had that cover a lot of topics related to HIPAA. We have specific client alerts, and if you're not on our client alert list, we'd love to have you, so send an email about that. We have other types of publications that you can access, and you might remember at the beginning of this presentation I referenced some written materials that were produced by Kim Stanger, whose picture you can see on this, and those are available on our Holland and Hart website, and I would just encourage you to look at those. Also, I would encourage you, our next upcoming webinar is a week from today, and it's responding to HIPAA breaches. So it follows right in line with this one where we talked about breaches and how to respond to them and what to do. We thank you for your participation today. I do see that we have quite a few questions that have come in. What I think we'll do is we will put our answers to those questions together and email them. We have that ability to do that, to answer them so that we can be thorough and not go past our 1 o'clock time, which I see we have hit right now. So thank you all for participating, and we look forward to working with you again.